Okay, well, thanks for coming. You're intrepid people. I haven't noticed it's snowing outside or not yet, but hopefully it won't be too bad. At any rate, I'm Mitchell Yell. My partner in crime here is David Bateman, and David and I are going to be talking about our experience as due process hearing officers today, especially as regards of free, appropriate public education. So that's what we're going to be talking about for the next few minutes. And if you have any questions or queries, feel free to bring them up. Or we have our emails there. You can feel free to email us, and we'll get back very quickly. Also, before we get started, I'd just like to thank Jolly and her crew and Dale and everyone for the excellent job they do. This is the 10th annual Focus on Inclusion. I've been fortunate enough to be at all of them, and it's a really great conference. And they also have a super conference in the summer on special education law that I would encourage you all to look at or attend. Now, before we get busy, the State Department has asked that and I'll put this up later if you don't want to take a picture of it now, that there's a questionnaire on the IEP system, and they have a URL that you can go to just by scanning this and answer a brief questionnaire. I will put this on later, and you can do that. And also, the URL can be reached by scanning that little critter on the back door. Not Dale, but the other one right there. And that will get you to the evaluation page. So, at any rate, what we wanted to do today is we'll talk about free, appropriate public education, especially with respect to due process hearings. And just a little background, my name is Mitch Yell. I am a professor at the University of South Carolina and a Tier 2 hearing officer in the state. And I've been a hearing officer for probably about 15 years. We don't have a lot of hearings. We're no Pennsylvania in terms of hearings. We just have a few of them. David is a professor at the University, or Shippensburg University, and was a hearing officer up till about 10 years ago, and probably done a little south of 600 or so hearings. So we've both had a large experience with hearings, and so we're going to be talking about, in fact, our presentation today, we're going to really be talking about FAPE, but we're going to really be doing it from kind of the lens of a hearing officer, or what we've perceived as, in our experiences as hearing officers. And I should say we both also served as expert witnesses and in hearings primarily, and so we have experiences there. Just to talk about the kind of errors that school districts tend to make that are very serious and could lead to a denial of FAPE. So it's very important that we pay attention to due process hearings. And let me, I had mentioned already, David's heard something like 600 hearings in which he's issued rulings. I've been a hearing officer for about 15 years. In South Carolina, we have what's called a two-tier system, and I am now a state review officer. And I'll explain it right now. In 1991, 25 states were what are called one-tier hearing states. What that meant is that if there was a controversy at the IEP team level, where the parents and the school district could not agree on something involving the identification, evaluation, placement, or programming for youngsters with disabilities, our law, the IDEA, has a dispute resolution system whereby either the parents or the school districts can issue or file a due process complaint and have a due process hearing. Now, like I said, in 1991, 25 states had that system. This year, all but 8 states are now Tier 1. So the vast majority of states are Tier 1. And what that means is after you have your meeting in the IEP, things do not get solved. There is a controversy, and a parent or a school district files a due process complaint. Then it goes to hearing. If it goes to a hearing, in the vast majority of states, you will have a hearing set up, usually at the State Department, might be at the school district, wherever, in which there's a hearing officer, like David, and you'll have oftentimes a court reporter, you'll have witnesses, you have two tables, the school district and the parents. Oftentimes they'll both be represented by attorneys. Witnesses will be examined, cross-examined, evidence will be entered, and then the hearing officer will take and determine the facts of the case, because usually, of course, the parents will have one set of facts and the school a slightly different set of facts. The hearing officer will determine what facts are the correct facts, and then that hearing officer, he or she, will look at the idea and compare it to the facts of the case and decide, did a school district indeed violate a child's right to a FAPE, or did they meet a child's right to a FAPE, or did they confer a free, appropriate public education? Then the losing party, if they so desire, can then appeal to state or federal court. And then it goes into the court system, and we'll explain a little more about that later. Now, 8 states are still what we call two-tier states, where the same process occurs. A complaint is filed, a hearing officer hears it. It's usually held at the local school district. The hearing officer makes a ruling, but instead of going directly to the state or federal court, there's a second tier of administrative review where the parent or the school district has to appeal to the state review officer or state review board, and that's what I do now. So where David used to hear opening statements and closing statements and witnesses being examined and cross-examined and enter evidence, I don't do that anymore. Now what I do when I have a case, and then David would issue his ruling, and then either party could appeal if they wanted. And one of the things, we are in a system called cooperative federalism, where the federal government has powers, the states have some powers, and they operate together. But this is like the way Congress acknowledged that states have important prerogatives in educating youngsters with disabilities, by saying, if you as a state you provide any rights beyond what we provide in the idea to youngsters with disabilities, we have to meet the state standards. Now in some states that's a really big deal, like New York, California have a lot of rights beyond what the federal rights are granted to youngsters with disabilities through the idea. Indiana does not. Indiana has, well, for instance, the idea requires that transition services be included in a child's IEP and provided when a child turns 16. But what does Indiana require in Article 7? At what age do kids have to get transition programming? 14. So you see, we're here in Indiana, Article 7 is actually providing more than does the federal government, and we have to follow that. So you have to provide transition services at age 14. However, a state could not say, for example, we don't think 16 is that important, so we will provide, in our law, Article 7, we're going to provide that schools have to do transition programming by age 18. They can't provide less, they can provide more. And the only area, really, in which you provide more is in transition services. See that? That's what that means. It includes preschool, elementary, or secondary education, and is provided in conformity with the IEP. So what does that mean? It means essentially the IEP is a blueprint of every child's FAPE. So every FAPE case that gets heard by a hearing officer or by court is going to involve that individualized education program. Thus, it's very important that we really attend to this document and what it provides. Now, this definition is not the clearest definition. It doesn't give a lot of information. It just says the IEP basically is a FAPE and a few other things. And that was actually deliberate. In the Board of Education v. Rowley, the U.S. Supreme Court, in opinion written by Chief Justice at the time, William Rehnquist, said that, that essentially we would have hoped for a little more from the federal government, from Congress, in helping us to interpret what a FAPE is, but we didn't get it, so we have to interpret that anyway. So it's very important that we also understand, in addition to this, what it is that the courts have been saying about special education services. And it is important to understand that this was a deliberate thing. Congress meant to do this. There was a fellow named Robert Stafford, who was a senator from Vermont, who was a co-author of the then Education for All Handicapped Children Act. And what he said is we deliberately didn't write a full description of what a FAPE was. Instead, what we did is we created a baseline mechanism, the Individualized Education Program, and that is what a FAPE is. Now, let me skip through this. The way our system works legally, as I mentioned, with the due process and all that, is a little bit different than how the federal system works. Now, of all the cases that are heard, the vast majority, attorney can either bring a case in special ed to a state court or a federal court. Almost always they go federal, because the idea is a federal law. Now, you have Article 7, which is a state law, but that is the same thing as the idea, with the exception of that one little difference. It's virtually the same thing as the Individuals with Disabilities Education Act. Now, this is how generally the federal court system works. There to talk about are brought through due process into the federal system. This is how the federal system looks like. There are 3 levels of courts. The first is the U.S. District Court. Every state has 1. Some states have as many as 4. And then there's some with 2 and there's some with 3. But there are a total of 94 district courts in the United States. The next higher level is the Circuit Court, or the U.S. Courts of Appeal. There are 13 of those, 12 of which could hear special education cases, and that's the second or higher level of court. And then the last court is the Supreme Court of the United States, and that is the most important court in the land. And what they say is precedent. It's binding on everyone in the United States. Now, let me show you what this looks like. Let's see, let me go back here for a second. Won't go back. So I'll try this. There we go. Okay, this is a map of the United States, and I have sometimes asked David to point out the state he's from. It's taken him a little while, but he usually finds it eventually. Pennsylvania, right over here.
I'm moving, that's why.
He's moving, yeah, that's his excuse he always gives. I want to move. And here you are in Indiana, there I am in South Carolina. So you see, every state has between 1 and 4 district courts. And if you look real closely, you see these little dotted lines. That is where the different circuit or the district courts are. So like Iowa has a northern district and a southern district. Most states, like Indiana, have just one. And so when a district court says something, that's pretty important. Why? Because you know if a district court in Indiana has a FAPE case or an LRE case or something, pretty much every hearing officer is going to make a decision with respecting that decision of the district court, and that's called precedent. But let's say there was a Indiana FAPE case that went through the due process hearing system, was heard by your district court. The district court made a decision. Now, either party can appeal that if they want. They appeal to the higher level of court, which is the U.S. Court of Appeals for the Seventh Circuit. because you're in the Seventh Circuit. Now, let's say it was a FAPE case. The judges, there's usually 3 judges that sit on each panel of the United States Courts of Appeal, and they hear the case on FAPE and they decide for the parents. That is now law in the entire Seventh Circuit, because every lower court judge, every hearing officer is going to perk up their ears and follow that decision. Now, if at that point, either party could appeal the decision. And of course, it's almost always the party that loses will appeal the decision. And in the third or highest level is the U.S. Supreme Court. So the appeal would go to the Supreme Court. And they don't hear every case. They hear very few cases, actually. Probably about now they're probably averaging about 8% of the cases referred to them every year, appealed to them every year, they will hear. So this year out of 1,000, they maybe hear 80. But that's really important, because every lower court judge, U.S. Circuit Court of Appeals, district court judge, hearing officers have to follow that ruling by the Supreme Court. So that's very important to understand that. Now, we have a kind of a special system. We have this due process hearing system. Before people can go up, either party could appeal to a federal court. So in the 46 states, you have one tier. So the parents have to go, or the school district, go to a due process hearing. Then they can file a suit in court. Then either party can file a suit in court. In South Carolina, where we have a 2-tier system, they go through tier 1, then they appeal to tier 2, then they can go into the federal court system, or if they so choose. Now, with respect, how does this work with a free, appropriate public education? Well, essentially, one of the case I mentioned, heard in 1982 by the U.S. Supreme Court, was called Board of Education v. Rowley. Was the first case ever heard in special ed, and it was about FAPE. It was about a free, appropriate public education. And what happened in the Rowley case is that a young girl named Amy Rowley, very high IQ, 125 or so, was profoundly deaf, was being served in a school district. This was literally after the regulations to the Education for All Handicapped Children Act had taken effect. And she was served in a public school district who had written an IEP for her and had really provided very good services, but they decided not to provide sign language interpreters. So the Rowleys went to court, went to the due process hearing level, to the federal district court for the U.S. Court of Appeals for the Second Circuit, and at the court levels, the Rowleys had won, because they contended a FAPE should involve equal educational opportunity between youngsters with disabilities and youngsters without disabilities. And a FAPE would essentially mean that a child would achieve to their maximum potential. Well, I went to the district court, and the district court sided with the Rowleys, saying that when we provide FAPE, what that means is we have to provide an education that allows a child to benefit to the maximum extent that they can. So it has to maximize education. It was appealed by the school district to the next higher level, which is the U.S. Court of Appeals for the Second Circuit. They affirmed that decision, essentially meaning FAPE means providing an education that allows a child to reach their maximum potential. The school district then appealed to the United States Supreme Court, and they decided to hear the case. Well, it was real significant, because that was the first case in special ed and the first interpretation of a FAPE. And essentially what they did is they said, remember that, well, we kind of wish we had a little better definition to work out of, but we don't. So nonetheless, we have to decide what FAPE, what Congress meant when they decided a FAPE. And what the court said is, for us to provide a FAPE to a youngster with disabilities, we have to meet 2 criteria: the procedural and the substantive criterias. And what that meant, essentially, is the first thing that schools, districts have to do in providing a FAPE is they have to meet the requirements of the law. They have to know what the law requires, and they have to meet those procedural requirements. So one of the things we were talking about in the last session is that idea, if you need a sleep aid, take that sucker to bed with you at night and read it. It'll put you right to sleep. David pointed out the procedural safeguards. Notice in Indiana is kind of the same thing. It'll put you to sleep. But those are very important because those are the procedures of the law, and we have to follow that. Now, I was a teacher for 14 years in Minnesota, and I remember at the beginning of every year, we had to sit and listen to the procedural manual. Our special ed director would talk about all the different procedures we had to follow because they were very important. We have to follow those procedures. So the one thing the Supreme Court did is said, we're going to give a test to lower courts and hearing officers to use in deciding FAPE. And that's our first thing, the procedures. Did the school district follow the procedures of the law? The second thing they said that comprises a FAPE is what we could call the substantive, or the substance of the program that we are writing in our IEPs. And what the Supreme Court said in 1982 is they looked at Amy. Amy was a bright little girl. She was passing from grade to grade. She was at the top of her class. And so they said, well, clearly Amy must have achieved educational benefit. And they also mentioned, note, by the way, that this only applies to Amy because not all students in special ed are like Amy. But nonetheless, they said the school met their two-part test. They followed the procedures of the law, and they developed a program that conferred educational benefit. Well, in 2004, those of us who are hearing officers had a little bit of a new section was included in the idea that said essentially a decision that's made by hearing officers must be based on a determination of the substantive grounds. Did a child receive a FAPE? So in other words, they were saying, yeah, this is still important, but this is even more important. The child must benefit from their education. Unfortunately, that turned out to be, they said there are some procedures that are so important that violating them would be a violation of a child's FAPE, but that's not always the case. There are some procedures that maybe are not that important that if they're violated, they result in harmless error. Those are not a big deal. But there are some procedures that are a real big deal. One of them is any procedural violations that is made by the school district that compromise or substantively harm a student's education. That is a very serious procedural error. And the most serious procedural error is if we do anything that a hearing officer or a court determines violates the parent's right to be involved in the development and formulation of their child's IEP. If we do that, that is almost certainly a fatal error. If a court or hearing officer believes that the parents were not involved, that's a serious, serious procedural error. Probably means or would lead to a violation of IDEA. Now, in my 14 years of teaching, I worked with youngsters with emotional behavioral disorders, and a lot of times we tried as hard as we could to get the parents involved, but they didn't want to be involved. Does that mean we can't do anything? Absolutely not. We have the responsibility to develop a free, appropriate public education for the child, but if we can't convince the parents to attend, what do we need to do? We need to document that. Most states have rules, like in South Carolina, if we can't get parents involved, we have to have two types of documentation that we use, two different modalities to try and get them involved. Maybe a home visit, telephone call, email, whatever. And many states have rules like that. So we have to make certain we try and get the parent involved, and we have to document all our efforts to get a parent involved. But if they won't get involved or we can't find them, we still have to develop a FAPE for a child. We still have to deliver an appropriate education. Now, what have we found to be the most serious errors in our role as hearing officers that school districts commit that lead to a denial of FAPE? What are the most serious school district errors? Well, let's go back and talk about the procedural and the substantive. Remember, the procedural just means knowing what the law requires and following those. What are the most serious errors that we found? There's really 4 of them. Failing to properly conduct child find activities. And we'll talk about more of these in a second. Failing to conduct a full and individualized assessment. Failing to involve a student's parents in IEP formulation, development, and monitoring. That is a very serious procedural error. Now, if we can't convince the parents to be involved, we need to document that. And then one of the most common ways in which school districts don't make a procedural error that excludes parents from the decision-making process is by using a process that courts have called predetermination. That is when we predetermine a child's programming or placement without the parent being present. And again, if we can't find them, if we document it, that's one thing. But if they are available and we don't involve them, and we write an IEP and kind of present it as fait accompli, here's our IEP, that's predetermination. That's an extremely serious procedural error that you want to avoid at all costs. Just to go over real quickly these issues in a little more detail. Number 1, child fine. Courts and hearing officers, if there's a potential child fine, a violation that school districts commit, we'll ask 2 questions. 1, did the school district have reason to suspect that a student may be eligible under the idea? And if they did they evaluate the child in a timely manner? If the answer to either of those are no, the answer is yes, the school district knew or should have had a reason to know that a child needed special ed and had a disability covered, and they didn't do anything about it, or either that they had identified but didn't evaluate, those are 2 very serious procedural errors that you don't want to commit. In terms of parental involvement, here's 2 quotes from schools. Notice this one on the 9th Circuit. Procedural violations that interfere with parental participation in the IEP formulation undermine the very essence of IDEA. And the Supreme Court has called procedural or parental involvement the core of the statute. So that's one procedural error you do not want to make. And if, again, you can't involve the parent, make certain you have good documentation that they haven't been involved. Now, those are the very serious procedural errors. These are the substantive errors that we found. And remember, the Supreme Court said that there's the procedural errors and the substantive. In Rowley, the Supreme Court said substantive errors, an IEP, this is the terminology used by the courts. The IEP has to be reasonably calculated to enable the child to receive educational benefit. Now so every hearing officer had to apply those 2 tests, procedural and substantive. So if David had a FAPE case, he had to look at those 2 elements of the Rowley test. If I had a FAPE case, I had to look at those 2 elements of the Rowley test. 1, procedures, 2, educational benefit. Now, the procedural thing has never been difficult for hearing officers or courts. Why? Because you look at the facts of the case and you decide. Look at the idea. Do they match up? Did the school follow the procedures? Yes or no? But when it came to the substantive part, the courts did have a difficult time in determining what is educational benefit. So if we look back at that map of the different states and circuits, one of the things we'll notice is that in most instances, I think six or seven of the circuits had ruled that that standard of educational benefit was very low. It just meant that schools had to provide some degree of some degree of benefit, no matter how small. Some degree of benefit. Well, in 2017, of course, the second FAPE case was heard by the U.S. Supreme Court, a case called Andrew F. v. Douglas County School District, and the parents of this young boy, Andrew, or Drew as his parents called him, were upset with the IEP because it didn't have much in the way of behavioral programming, and the child's academic progress had been stalled, so they appealed to the Supreme Court, lost at the due process levels all the way to the U.S. Circuit Court of Appeals for the 10th Circuit, and appealed to the Supreme Court because courts had different opinions about what educational benefit was. As I said, most courts said it's just a little bit, it has to be benefit no matter how small, some benefit is enough. But we also had circuits like David's circuits that were saying, no, it has to be meaningful benefit. And so the Supreme Court oftentimes will look and see if the circuits are coming up with different opinions, which they were about educational benefit. They want to step in and clarify. So that's what they did. They took the Andrew F. case and issued a ruling, and essentially what they said is that educational benefit means, they did away with the term educational benefit, and they said an IEP is reasonably calculated, must be reasonably calculated to enable the student to make progress in light of that student's circumstances. Now, they threw away, as I said, they threw away the term educational benefit because that had been confusing to the courts. And they decided we will use the term progress. Now, David and I were both at that Supreme Court oral argument. One of the justices, Justice Sonia Sotomayor, said that our task, they all seemed to pretty much believe that IDEA required more than just insignificant benefit, that did require meaningful benefit. But they said our task is, she said, our task is to come up with the right words. And the right word they decided on, the right words they decided on were progress. So they said an IEP is reasonably calculated to enable the child to make progress in light of a child's circumstances. What that means is now that I am still doing hearings, if I have a FAPE case, I now have to look at the procedures, number one, and then I look at the substance, but it's a new substantive standard. It's did the child make progress? Now, what that essentially means is the IEPs we write have to actually confer progress or be reasonably likely to confer progress. So what have we found in our due process hearings and expert witness cases that really are very serious substantive mistakes made by a school district? Number one is failing to establish the foundation of the IEP with a complete, accurate, and thorough assessment of all of a child's needs. Secondly, internal consistency of an IEP. Very important in ensuring we meet the substantive standards. And that just means the IEP is all concatenated, or it's all connected together. The needs that are identified in the present levels lead to other parts of the IEP. And then in terms of progress, the things we have found to be most important is that schools write, IEP teams I should say, write measurable annual goals and then collect data and report this data to students' parents, and that data has to be of the child's progress. Now, let's talk about a few of those for a minute, and then we're going to turn it over to David. Number one thing, substantively, is make certain your school districts are doing a thorough accurate, and relevant assessment of all of a child's needs. Doesn't matter what their disability is, you have to address all of the child's needs. Why? Because as essentially the assessment is the foundation of the IEP. A court in South Dakota used an analogy of a house in a FAPE case where they said, if the foundation is bad, it's likely the rest of the house will eventually fall. And courts, this has been shown in hearings and in court cases, if the assessment is not done correctly, none of the rest of the IEP will probably be correct either, because that is what is your foundation of your IEP. So assessment number one. Number two, internal consistency. What does that mean? That means you do your current relevant assessment of all of a child's needs, and you write your present levels of academic achievement and functional performance based on that assessment. And this identifies all those academic and functional needs of the child. It's very important then that the rest of the IEP also address those needs. Now, usually we'll have annual measurable goals on all these needs. Possibly not. I mean, if we have a need that a child get large print books in his class, well, you wouldn't have a goal on that. But you have to have a service on that, because every need has to have a corresponding service. Could be a special ed service, specially designed instruction. Could be related services, supplementary services, program modifications. But every need has to have a corresponding service. Then you have an internally consistent IEP. Too often in FAPE cases, what happens is we see IEPs that are internally inconsistent. And let me give you an example. David has probably plenty of examples like this too. 2015, one summer, I did a couple of cases of reviews of IEPs, of FAPE cases, I should say, that came up that were appealed from the first tier of due process hearing level. I remember one case in particular was of a young girl with an intellectual disability. And she had some pretty significant needs. I mean, she's only kind of mildly, or maybe you could say moderately, intellectually disabled, but she had some clear needs, and the parents were concerned that the IEP was not addressing all her needs. And so what they did is they filed for a due process hearing. And the hearing officer looked at the facts of the case, applied the law, and said the school district had prevailed. The parents then appealed to the next level, or the state educational agency, and they assigned, Barbara Drayton, the attorney, assigned the case to me. So what I did is I went to the district office, I got the testimony the court reporter had done, and there was like 1,200 pages of it. Then I got the exhibits. There was 3 boxes of about 90 different exhibits, and always IEPs will be part of those exhibits. And so I just sat down at my dining room table, read the decision, looked at before I read the decision actually, I read the transcripts of the case. I looked at the exhibits, because one of the things you'll note in the transcripts of the case, I'm sorry to see you spilled on yourself, David. Hopefully it'll dry in a few minutes.
I have a drinking problem.
Oh, okay. So I looked at the transcripts, I looked at all the evidence, and one of the things I found in the evidence is the first thing I drew out was the IEP. Evidence number one was the IEP from her 3rd grade class, or when she was in 3rd grade. So what I did is I went through that IEP, and I looked at, they had assessment data, looked like a real thorough assessment, looked at the present levels, and they said she has speech and language difficulties, she has problems in reading, and they were very well outlined in the present level statement. She has a problem in socialization and behavior, and she has a problem with math. So the next, I thumbed through the IEP, got to the goals. There was a 2 speech and language goals, about 3 socialization behavior goals, couple goals in reading, but no goals in math. So then I went to the last part of the IEP, and I looked at the services, and I found there's speech and language services, frequency, duration, location, all that was mentioned in the IEP. There was socialization, behavioral services provided. There was counseling provided, a number of other things. There was reading provided, specially designed instruction in reading, like an hour a day, every day of the week. And then I looked to see math, because that was a need. And what should I find? Nothing in math. So we had a need, but it wasn't addressed in the goals. It wasn't addressed in the services. What was that? An internally inconsistent IEP. Didn't hang together. There was a need that wasn't addressed in the rest of the IEP. On the basis of that, and I found that in virtually all of the IEPs that were done for her, I overturned the hearing officer's decision because he had not found that error. Well, he was an attorney, not an educator, so I guess I understood that, but nonetheless, he had made an error because it wasn't internally consistent. And what you need to understand about this is that just means there needs to be a direct relationship between your present level statements and other components. And this was taken from the federal regulations in 1997. The U.S. Department of Education issued a question and answer document. And one of the questions was about what is the relationship of the present levels. They were still called present levels of performance at that time in the rest of the IEP. And the question was answered by officials at the Department of Education like this. If the present level statements describes a problem with a child's reading and points to a deficiency in reading skills, the problem should be addressed under both goals and specific special education and related services. Again, you must have an internally consistent IEP. So that's the primary procedural problems we've found. Most of the substantive problems. Now David is going to come up and start talking about another area of substantive
All right, so I'll do what I can. But what's interesting about this is I want to talk about a variety of things as we're talking about this. And we come at this from different perspectives. As a second-tier hearing officer, he sees the appeals. I was a first-tier hearing officer where I'd actually would be the one who would go into the school and actually hear the cases, see the parents crying, see the upset, and see the teachers get frustrated with what's going on. It's actually a very emotional process. I've stopped doing that. Now I work with school districts when they've been sued. And haven't consulted on this due process hearing since yesterday, so I'm on break right now, so it's kind of cool. But right now I'm working involved. There's a class action lawsuit against the Oregon Department of Education. I'm the fact finder for that case, and I've been working on that. I was heavily involved in the Flint versus ACLU case with the Flint water crisis. So I'm involved in some of the big cases out there. But I want to share with you just a variety of things. He's been talking about the process part, and he very nicely talked about the importance of laying a very strong foundation for what you're doing. Because without that foundation, it truly is the most important part of the IEP for me, is the present level dictates everything. It really does. It drives the services, it drives the needs, it drives the levels, it drives the placement, it drives everything. So you need to make sure that you have a really good foundation from which to build this on. And so, all right, I'm just going to do this to keep Dale awake back there. But I share this with you is what I want to talk about this also is the fact that he alluded to this just a few minutes ago. You need to make sure you get parents involved. And this is so much easier said than done. I'm well aware of this, because right now I'm hired to go to. I only go to contentious IEP meetings. I don't go to the happy ones where people people bring treats and it's over in a half an hour and you sing Kumbaya. I don't go to those anymore. I hear they still exist. I go to the ones where there's an attorney, two attorneys on the phone. There's an advocate there. We've gone through the IEP multiple times. But one thing I want to highlight for you is, since it's difficult often getting parents to participate and get information for this, is what I do. I'm the one who actually leads the IEP meetings, even though I don't know anybody in the room sometimes. But we do introductions of everyone in the room. First thing, obviously, things like this. And I've got horror stories on districts not doing that. But the second thing I do is I then turn to the parent, and then have the parent say, I say to the parent, tell us about your child. Okay? it serves multiple purposes. First thing, it reminds us we're there to talk about a child. We're there because of a child, and we make sure because some people don't even know this kid's name. It's really interesting because I'm dealing with, I was in a secondary IEP meeting for a kid in secondary school the other day. Teacher who happened to be free was brought in. This teacher had never seen this kid before. And I found out who this teacher was. I said, you're the one who's like, yeah, you're free. Have you ever had this kid? No. I said, you go cover the class of the teacher who actually knows what this kid looks like. We might be just for a short-term thing, but we need someone who actually understands what this kid looks like and what this kid interacts with like this. But we talk about a child. Remind us that we're there to talk about a child. Second thing, it grounds us, but it also then we take that information and we embed that parent statement into the present level. But it was why I share this with you, and this is a story some of you may have heard me say before, but I was involved in one about, it was in September, right before COVID. Some of you may, remember how long ago that was? It was yeah, who knows? My kids both lived away and now they're at home, damn, so it's interesting. It's interesting about this, so they're moving, because we're moving. But it's interesting about this is, yeah, we told them that this week. But I share this with you is, we had one where at the end of September, the third grade girl with an IEP relating to reading. I was brought in because the parents had previously sued about it, another kid, but just wanted to make sure it was a clean one. We had a really good IEP. I was very excited about this, things like this. I turned to the parent, and we say to the parent, tell us about your child. Parent says, I know we're here to talk about my reading, but my daughter has no friends. And she doesn't want to come to school anymore. It changed the whole dynamic of the meeting. Rightly so. Rightly so. We're now focused on so we had the teacher there. We started more cooperative group activities. We started more sharing activities, more opportunities for others to participate in things like this. And we luckily were in the timeline, so we deferred the remainder of the IEP. We came back 3 weeks later. Parents said, my daughter has someone who sits with her at lunch. Someone's playing with her on the playground. Let's talk about reading now. Pay attention to the parents. Pay attention to what they hear, pay attention to what they're saying, because they have valuable information and we need to honor them and we need to respect them. I mean this literally, is that parents, we often dismiss parents and they're asking for things. I do not blame parents for searching on the internet for things that will help their child. In fact, I strongly encourage parents to do this. My mother-in-law is 90 years of age. She just turned 90 the other day. And she's sprightly. I think this is my future. She hikes up and down this hill every day 4 times because that's what she said she's heard you're supposed to do. It's a really steep, long hill. It's like, go for it, woman. And I think that's my future because my wife's very energetic. But I share this with you is my brother-in-law is 63 years of age and has profound intellectual disabilities. He needs help toileting. He needs help getting dressed. He's nonverbal. He knows maybe 10 signs, of which 8 relate to going to McDonald's right now. And so it's really interesting. You drive him along the highway, you think he's asleep, they send out signals to him. And he's thinking, yeah, he's pointing up to these places. The golden arches are everywhere. He sees all of them. I share this with you is that she spends about an hour every day on the internet looking for ways to help him improve communication. Parents are doing this, and we as parents, we want what's right for our child. And so when you have a parent coming in and making a demand on you, please pay attention and think about their perspective on what's going on and listen to them and honor them and listen to what's going on. Now, do we have to give them everything we want? I was involved, I don't think I've ever told you this story. I was involved in one where I was brought in where it was one of the cold winters, kind of like this winter, at least in Pennsylvania it's been cold. I have no idea how the hell I'm getting home tomorrow, by the way. I'm driving. Yeah. Ohio, here we come. Yeah, right. So what's interesting about this is I was involved in it was a winter one. And I remember this real specifically. Parent had gone on the internet and found out that their 5th grade boy with emotional problems, what would solve his problems with emotions would be to swim with go to Key West and swim with the dolphins. And because he has trouble getting in the water, that they needed his 7th grade brother to help go along to help him get in the water. So I said, well, how about we go talk about this? So we went in the next room, and I'm sitting there I'm the person expert brought in to help consult on this, and they said, what should we do? I said, send him. I said, yeah, send me to take data. Because you need someone neutral to go down there and observe what's going on. I've never been to Key West, so I have no preconceived notions about what's going on there. I'll go take data and things like this. After they got over that, we realized, is it necessary for him to receive an appropriate education? Is it necessary for him to receive FAPE? It wasn't. So we said, okay, we walked in. We think we have a program that will provide your child FAPE. Here's things like this. We don't think we appreciate your offer, but we don't think what you're asking, but we don't think it's necessary to receive FAPE, and we move on. But you have to consider, is it necessary? You have to consider every single request as a part of this, and I can't reiterate that enough. So we're going to talk more about this. So Mitch laid a wonderful foundation for this thing, and I mean this with no pun intended, but the present level statement drives everything. The second part, though, I'm serious about this, what we can learn is dramatically increasing our progress monitoring data and use that for effective programming. Because between the two, if you have a really good present state, you have child find and a really good present level statement, and then you have good progress monitoring data on what's going on and use it appropriately, you'll reduce dramatically the amount of litigation that you would be involved in. And get this, it's better for the kid. It's better for the kid. It's not just legally defensible, it's better. And I'll explain that for you, things about this also. Okay? But you can see this. And I say this to districts all the time. Because what I do with a lot of districts, I work with them very specifically. In the old days, we had this thing called FedEx. Some of you may understand what it is, but they would FedEx me documents on Thursday night, and then by Monday morning, I'd meet with them and talk to yay or nay about whether they should move forward on a litigation or should we settle. And first thing I do is I go through the IEP, then I look, if they don't have progress monitoring data, I'm done by Thursday evening. I have a weekend. And that happens in the vast majority of the cases. We don't have progress monitoring data to indicate yay or nay about whether the child's making progress or not. So if you look at the number of court cases, if you look at the court cases that percolate up through the various systems, and Mitch is very, very correct that we don't see anything on COVID because it takes a while for that to flow through the process. And so you will next year probably see a lot on COVID. You're starting to see, we've seen some unmasking right now about kids with immunocompressed sensitivity issues. But I share this with you is when I look at this, there's no progress monitoring. We just settle the suckers. Settle this. The vast majority of cases settle because school districts don't have the right stuff. Okay? Mitch was talking about the cost of this. Okay? And you'll appreciate this. This is going to say, I know this is being recorded, so. But it's interesting. We did a study in Pennsylvania where I do most of my cases, but now I'm also working in Michigan, Oregon, and a few other states. But it's interesting to win a slam dunk case on just basic an evaluation. You got a kid where you think you need to do an evaluation, you want to parent won't sign the permission, but you want to do the evaluation, $22,000 to do that case. That's just on a case you feel like is a easy, that's an easy case, put the evidence in. Very, very rarely is a hearing officer going to say, no, I don't want more data on a child. Right? But typically you're not going to ask for more data on assessment on a child unless you really feel it's necessary. So what we're seeing, though, you'll appreciate this. Attorneys who represent parents know this. So what they're saying is, we won't go to hearing, we'll settle for $8,000. Okay? You go to a school board, okay, win $23,000 maybe, or settle at $8,000. You weigh the odds on that one. You play the odds on that one. Okay? It's not like they're going 22 versus 21, but that's a sizable chunk. And we have school boards are having to make these decisions about this because they have to be fully informed about what's going on. And school board members don't often have a lot of knowledge about special education. CEC actually does have a really good new book that just came out about 7 months ago, what's called a School Board Member's Guide to Special Education. It's become wildly popular. I wrote it, but it's all right. It's true. But when we were writing it, we thought it was going to be like, what the joke was, it was going to be in large print with a lot of pictures. But what's interesting about this is, but it kind of guides him, and I don't get royalties off this one, but it works out really well. So keep this in mind. Wait, we've got more, okay? So we have to think about it. I'm going to highlight some things for you. To make functional progress is academic and functional advancement. Not just, you see this, it's not just, it doesn't stop at academic. We need functional advancement. And this is what trips up a lot of kids, is that we don't have behavioral data on these kids. We truly don't have good behavioral data. We have academic data out the wazoo on these kids, but we need good behavioral data. So what you need to think about doing is just maybe training your paraprofessional aide, because I know you probably have more than you need, and they're sitting around bored. And they're all very well trained, by the way. It's interesting about this. I know how bad it is out there. But you train them, just take some frequency and duration data on what's going on. Just some basic frequency and duration data, and take it at the same time every day. Like, how frequently does the kid go to the bathroom? How often do they get up out of the room? How often are they fiddling underneath the seat? Or in the playground? How many times do they interact with someone else? Just basic data on this, and just so that you have some behavioral data about what's going on. We don't do that enough. We absolutely don't do that enough because we rely so much on just grades and tests. We need behavioral data to support this, because that's what trips up a lot of these kids. It's not so much, yes, academics is an issue. I'm not disputing that, but it's often the behavior problems that cause these kids the problems. And then we don't have the data that support that, and we need to figure out how we can do that and do better with that. Wait, there's more. Okay. I'm going to start flowing fast. Okay. What have we found to be some of the issues? Okay. Implementation. Okay. We spend a lot of time developing these IEPs. Okay. Don't do a cost analysis. It'll piss you off. All right. All right. But we spend a lot of time. Please, just don't do it. Right? But things like this. But we need to then make sure we implement the little suckers. And because because one of the things, I think when those of you who've been involved in a discipline case, what is the first thing we look at? Did you fully implement the IEP as the? Then most times we can't say yes. So what do we do with those? We settle. All right, you're going to hear me say that often. Okay, and it's not always best, but it was what we do. Okay, so we need to make sure we're implementing the little suckers. So what I recommend, and I do a lot of workshops with principals. CEC also has a great book for principals, by the way. It's interesting. But it's interesting about this is I tell principals periodically poll a few of the IEPs that you have in your district, and they go meet with the teachers to say, are we doing what we're supposed to be doing? Are we implementing the IEP as listed here? Okay? It's not a punitive thing. It's better for you to find this out before someone from outside finds this out. I'm very serious about this. And if you're not doing what's there, then determine what do we need to do to change this so that we're actually implementing what we're supposed to be doing. And if the child, I've seen IEPs where we had an IEP where a kid came from out of district and they said he needed 4 hours of instruction on a daily basis. Sounds intense. Kid didn't need no stinking 4 hours. He needed like 45 minutes. So the district was doing 45 minutes, but they did no evaluation on it. They just went ahead and did it while the IEP said 4 hours. Kid brought a knife to school. You know how much fun that is, things like this. And so we looked. Were we implementing the IEP as articulated? No. Was it needed? Probably yes. But so we settled, because we weren't doing what we're supposed to be doing. I'm all for changing a kid from 4 hours to 45 minutes if you have evaluation data that clearly articulates that. Because one of the areas that trips up districts a lot is kids who are getting 2 hours of service in elementary school. And then they go to middle school, and all of a sudden they go to 42 minutes. Okay? It's as if they've been fixed. Not like I recently did to my cat, but it's as they've been fixed. Okay? And I share this with you, is I'm all there for you if the kid only needs 42 minutes. Right? I'll be there for you. But if the kid needs 2 hours and you've cut it down to 42 minutes based on administrative needs, you're not going to win. We're going to settle. Understand this? So so make decisions based on the kid's needs, not based on the administrative needs. Okay? Second thing, make decisions based on the kid's needs, not based on the kid's disability label. We get locked in that we need special autism services for kids. Okay? Autism is one of those really big umbrella terms. Okay? Really big umbrella term. Same, not as big as OHI, but that's a different point. OHI, I do workshops for school board members. They think I make up that term. I make up a lot of terms. I don't make up that one. But it's interesting about this is there are not special autism. Their services need to be tied to the child, tied to the individual needs of the child. I was working with a kid about 3 or 4 years ago who every kid he was a 9th grade boy, every kid in his class had a class for kids with intellectual disabilities, every kid in his class had to take adapted PE. So he had to go to adapted PE. He could dunk a basketball. I'm putting it out on a limb here. If you can dunk a basketball, I don't think you need adapted PE. He was also a backup guard on the football team. Okay? He didn't need no stinking adapted PE, but decisions were being made based on his label, not on his individual needs. And that's one of the things that trips up districts left and right, is they do that all the time, that these kids need special services just because they have such a label. That is not the case. All right? Because there are kids out there with autism who don't get any special ed services whatsoever. Okay? And there are kids with learning disabilities who need residential programs. Okay? So just because they have a certain label doesn't mean there's specific services that are tied to that. Okay? So keep that in mind, right? But more. I'm going to start talking faster. Okay? Implementation is important. Make sure that you are implementing these things. So check on this, pay attention to this, and it's addressed to the individual needs. You have these slides, all right? I'm going to keep going. A materiality standard. What is important about this is you have a number of court cases, and these are pre-COVID. These are pre-COVID. Those of you who've heard of COVID, these are pre-COVID. Okay? And these are things like this. We've had problems with implementation. I'm betting your districts have had problems with implementation since COVID. Write that down. Okay? Now, why I say this, and why I appreciate the fact that you guys are here. I sincerely, first, the weather sucks. I'm aware of this, all right? My parents have been texting me all afternoon about this. How are you going to get home tomorrow? Have they canceled? Are you leaving right now? No, I'm driving. Not till tomorrow, all right? We'll see. We'll see if the Subaru's all-wheel drive really works. Why I share this with you is there is a perception among people out there, parent attorneys, that there's a lot of money in education. The extra money, all the extra money that's been flowing into education of late. Why do people rob banks? Because that's where the money is. You're going to see, we're expecting, we've seen a dramatic increase in attorneys getting into this because of the need because they're perceiving that kids have not received appropriate services over the last 2 years, and they're suing for this. So I'm expecting that you guys need to pay attention to this, because you're going to see a dramatic increase in this. And when I say that I can get a lawsuit in your district, I can get a lawsuit in your district if you want. All right? Seriously, if you want this, I work with a number of firms out there, but it's interesting, it's not something you want, but the reality of this situation is we are a profession that is defined by a law. I wish we didn't have to have this, what we're talking about here. I wish we didn't have to have this discussion. I wish everyone did what they're supposed to be doing. The reality is that's not the case. The reality also is we have so much turnover in education right now that you have newly non-certified people providing services, running these things, that you're going to be on the hook for as if they were certified. Okay? And I share this with you. My daughter's about to get her master's in special ed and be newly certified. She wants to work with kids with autism. She called me the other day and said, "Dad, do you think you could call some of your friends and help me get a job?" I'm not worried. I said, "Honey, I think you're going to be okay." "Are you sure? Are you sure?" I said, yeah. I think where she's student teaching is going to grab her. So yeah. So it's kind of working on this, okay? I'm going to keep going faster here, all right? More cases on implementation. Pay attention to this. Read about the per se approach here, consisting of experts. You need to make sure that you're doing what's right for the kid. Mitch very closely, very nicely articulated the procedural violations. You need to have the right people in the room following the timelines. That's one of the two prongs we look at. The first one is procedural. The second one we're going to get to is substantive. The procedures are, that's why your special ed directors hound you for making sure that you've met your timelines. Get the right processes. Get the right people in there as a part of this, okay? So more material implementation. Failing to provide the agreed upon services and not providing the agreed amount of services. Two very different things. You're not providing what you're supposed to be doing, but then you don't provide the extent of what you're supposed to be doing. Again, it gets back to why spend all this time in an IEP if we're not going to do this? I'm very serious about this. Because that you have to think, and I'll highlight this for you in a few minutes, as we highlight this as a contract, you have to pay attention to this. So based on our experiences, what do we recommend? First, stay in education, please. Please, we need people to stay in education who are smart and things like this, okay? First, don't miss the small things. Names, dates, get those right. My sister has a child who had an IEP. On the first page of his IEP was his name. 3 pages later, he was a Kevin. Then he became a John. Then he had a sex change operation, became a Catherine. Okay? Make sure you at least have the kid's name right and read through these kinds of things. Second, don't say dumb stuff. Okay? And you think, okay, so we have a list of dumb stuff. All right? Okay? We don't offer services here? Here. Actually, I can summarize this for you. You can take this back to your team. Words you should not say. Never say never. Just don't ever say never. We never do that here. All right? Okay? Okay? Or, we don't allow that. Okay? Or, okay, I love this. Everyone is treated equally. No. These kids are individuals. The I of the IEP stands for something. I forgot what it was. Okay? I'll have to pass this question on to the powers that be as a part of this. No. The IEP team are the ones who approve this. Okay? Other terms you need to... Here are some terms you actually need to say. Okay? First, you need to say the word individual a lot. This is individualized or individual to this child. Use that term. Second term, okay, is we feel this program is appropriate for this child. And third, we have fully considered all the information. Individual, appropriate, fully consider. If you can say those things and mean them when you say them, truly mean them when you say them, you'll have a lot more success and a lot more, and it'll be better for the child. I really do mean this. Individual, fully considered and appropriate. I mixed it up there, but things like this. Because that's what our obligation is. We fully consider what's being asked of us. And that we've individualized it to the child. And what we're providing to the child is an appropriate program. Okay? Individual, fully considered, appropriate. Use those terms and mean them when you say them. Don't just give them lip service. And make sure that you do those kinds of things. All right? More stuff on here. All right? Recommendation 1. Okay? Avoid procedural violations. Just this is the one. This is the easiest get. Get the things in there. Get the things in there on time. Get the right people in the room. Okay? Also make sure you get a draft to the parents ahead of time. Get a draft, and one other thing, and if you don't have a full draft, like if you're like an 80% draft, get an 80% draft to the parents. Get that to the parents so they have something to look at, and then articulate to them what is the difference between what you sent them and the final draft that you have. The second thing, make sure you use the word draft 40,000 times in the first 15 minutes. Get hats that say it, plastered on foreheads, get a stamp, whatever, things like this. Have your ringtone say, we're only reviewing a draft. We're only reviewing a draft. Do whatever you need to do. Draft, draft, draft. It is a draft. Next thing, no matter what the parent asks for, you change something in the IEP. You change something. There's that classic special education acronym called CYA. Okay? I don't remember what it stands for, but it's CYA. Okay? Things like this. But it's interesting about this is you keep a version of the original and say we listened to the parents, attention to the parents, and we made changes based on the parents' suggestions thing here. All right? Keep that in mind. Okay? But avoid the procedural violations. Wait, more. Okay? Next, when developing the content of the IEP, okay, make sure it addresses all the kids' needs. All. So when when I'm brought in for cases, I make sure I talk to everyone who interacts with the child. I leave no stone unturned. I'm working with a district right now who, for the past couple months, has just marking a kid as down as tardy because he keeps missing the bus. Well, how about we look at why the kid is tardy? Well, we found out that there's a kid on the bus who bullies him. So he doesn't want to go. He doesn't want to ride the bus, so he walks the 2 miles to school. So he's late to school. Okay? Instead of just marking these things down, get interview. And what happened is that the bus driver told the school secretary went out because of COVID, so they brought in a temp secretary. You can see how this would happen. The school bus driver told the temp secretary who didn't pass this up the chain. The school bus driver didn't know it was a temp secretary, did what the school bus driver was supposed to do. Okay? You understand why these things can happen, but make sure you talk to everyone. Get everyone so there are no surprises. Because you don't want to be in a due process hearing where someone says, yeah, you talked to the teacher, you talked to the PE teacher, you talked to the history teacher, but you didn't talk to the math teacher where he's failing. I mean, please, play that out. There are very few dramatic moments in due process hearings. That could be one, okay? But you look at all the services, on what's going on, and talk to the related services personnel, okay? Another recommendation. Make sure that the goals, and you heard me say this before, everything is appropriate to the child. It is tied directly to this child. It's not directly to a curriculum which we're going to squeeze this child into, or the class that happens to be available. It's appropriate for this child. Second thing, it's ambitious. It's ambitious. We're going to be pushing this kid forward. We're going to be pushing this kid forward so that this kid makes progress, because that's what our obligation is. And the third thing is it's measurable. And I don't mean this as a pun, but if it's not measurable, it don't count. If you can't measure it, it's not, seriously. I've seen progress monitoring statements on reading where it says, kid tries really hard. That warms my heart. But that's a sucky update on what's going on. All right? That's the formal term, sucky update. But it's interesting about this is you need to make sure it's measurable and you have clear data on this, because you need to graph the little sucker. The formal term we use in special education litigation is called interocular analysis. You need to be eyeball this. Okay? Eyeball what's going on. Is that graph, is it going up or down on this? So you need multiple data points in order to do this. I'll get to that in a second. But you need to be able to something that's measurable. Next point. Okay? Okay? Continuously monitor and measure your students' progress. Okay? And then you have data on this. Okay? Anyone here a speech path? Thank you very much. Okay? Why? When I do witness prep for speech paths, why are they easy to do? Because you have data for every time you work with a kid, right? Yes. Well, you should. ASHA basically requires it, right? Yes. Okay. Yeah. No, I'm serious about this. I love witness prep with speech paths. I really do. I really do. And I think some of them I got in the administration book. I wrote that with a speech path. And so, but it's interesting about this is we need more progress monitoring data from you guys. How much progress monitoring data? For if you have a 9-week marking period, I would like at least 6 to 7 data points. And that sounds like a lot. Think about it as small snapshots, not long videos. A 5-minute probe here, a 7-minute probe there, an 8-minute probe. You can do a 7-minute probe on a kid's goal once a week. It's not going to alter your curriculum that much. You can learn a lot in 7 minutes of a kid's oral reading. You can get a lot on kids' automaticity in math in 7 minutes. You can learn a lot in these things and get regular data on this. Same thing what I said earlier about behavioral data with parents. Get them to take these things. Get this and chart this and get multiple data points. I was working with the district a couple years ago. They had 1 data point per marking period. So I asked them to graph it. And they dutifully did. They drew the XY axis. It's right here. I couldn't tell if it was going up or down. Is it going up or down? What's right here? I said, that doesn't tell me crap. And so we settled that. All right? So understand, get regular data and use it and pay attention to this, which builds me to the next point, okay? Provide frequent and systematic data reports to the students' parents. Keep the parents informed about what's going on. There should be no surprises to the parents. No surprises whatsoever about what's going on. A lot of the due process hearings that we're involved in, it's because the parents, there's a communication breakdown. And the parents, and in fact, only want the attention of the school district because they're not getting the attention otherwise. The moment a parent says due process, they get all the attention. There's a level, I understand reinforcement theory is the best of any behaviorist out there. My daughter is about to go to BCBA. And so, yeah, she's not going to have problems getting a job. But the interesting about this, as I share this with you, is they're basically getting the attention that they are craving. And I don't blame them for this. So keep that in mind as we talk about this. But provide frequent and systematic data-based reports about what's going on. Okay? More importantly, okay? This is the first part. Mitch's whole first part was amazing and truly impressive. A really good foundation on present levels. This is I can keep going, but is because there's chocolate chip cookies up here. You don't want to see me on those. But it's interesting about this. You need to pay attention to this one. If you learn nothing else today, learn. And I'm not being hyperbolic. I'm very serious about this. Take progress monitoring data on a child. And if you find that the child is not making progress, change something. Change the grouping, change the seating, change the intent, change the reading material, change grouping, change where he's sitting, change how long you're doing this. Change something and then document the snot out of that. Okay? Because I would wish that if you just change one thing, it's going to work. Often you need to change 2, 3, 4 things. Because here, this is actually a very real special ed acronym. You ready? I'm going to tell you this acronym. It's KOSHK. KOSHK. It stands for new, as in K-N-E-W, knew or should have known. Most of the lawsuits I'm involved in involve this acronym, where a district has data that they knew that the child was not making progress, and they did nothing about it. I was working in a district, this is the pre-times, where they knew at the end of the first marking period, child was not making progress. They did nothing. And at the second marking period, child was not making progress. And at the third marking period, child was still not making progress, but they said it's too late to make changes right now. So we'll do it next year. We have a kid who we knew at the end of the first marking period was suffering, and we did nothing to change that. Okay? Who's the slow learner here, folks? And it's interesting, that is one of the biggest parts of what we see in lawsuits is what the term is comp ed. We go for back services that the child was denied. Luckily, in that case, the parent got an attorney who was a tax attorney, didn't understand special ed. We offered a nice settlement. We didn't jerk them around on this because the school district messed up. So we have to think about, pay attention to this, but make changes and then document. Not only is it legally defensible, but it's also better for the child. Child's not making progress, do something that alters. Because why I say this, these kids don't choose to have a disability. It's not like they wake up and say, you know, I think I'm going to have LD this week because it's a shorter acronym. I'll have autism next week because they have better bumper stickers. It's not like that. These kids have disabilities at no fault of their own. We need to do something to help them as part of this and work to provide services for them. Okay? More. Recommendation 7, ensure the fidelity of the implementation. I alluded to that earlier, making sure that you're actually doing this. You're implementing the IEP as written. And if the child doesn't need it, reconvene the IEP team. Or if the child needs more, reconvene the IEP team. These suckers are not set in stone. Change what's necessary. Okay? More. We have a list of resources. A list of free resources. But there's one that I really want to highlight for you. Okay? These are all free resources. The best one, the one I really highlight for you, because we're limited time here, is a resource called the IRIS Center. The IRIS Center, after the Ender Supreme Court case 5 years ago, the U.S. Department of Education wanted to come up with training modules, free training modules for teachers on how to implement what are legally effective IEPs for teachers, what their role is, and then legally effective IEPs for administrators. So the U.S. Department of Education reached out to Mitch and me. We wrote them in tandem with each other. They're free modules. They each last about an hour and a half. This could be amazing professional development for your school districts. Have them go through, their ticket in the door is they do this module, this hour and a half module, and then you basically take questions that they've generated from this module. Okay? These modules are mandated in multiple states. They have the U.S. Department of Education stamp of approval, what a legally compliant IEP is. But if you go to the Google and you type in IRIS IEP module, you'll see, I think it pulls up Mitch's, it's like 01, and the administrator one is 02. So I do a lot of workshops for principals where the principals have to take that the week before. Then I come in a week later because of the nature of adult learning. They process the information. We go through their questions and kind of make sure that it's consistent with what's going on. These are all free. This is all free stuff. This is all free stuff. Okay. The last thing, okay, is we wrote a book. Okay? Well, we do that in our spare time. Some of you go for walks and have hobbies. We write books. Okay? But it's interesting. This is a book on legally compliant IEPs. Came out about 6 months ago. It's now been adopted by a whole bunch of universities and colleges about for a class on IEP writing, things like this. Our goal, whether you like this or not, is to reduce litigation. And that really is our goal. We're in the process right now of finishing up a book on preparing for due process hearings. We need to talk about that, by the way. We have a chapter in there on how to witness preparation. If at some point you guys are going through a hearing at some point, again, it may happen, but it's nothing like you see on TV. And there's nothing that has prepared you for this. Let us know. We'll get you information that will help you with this. Here are our email addresses. We're going to be around tomorrow. You may not be here, but we're going to be around tomorrow. My parents say, when are you leaving today? I'm not leaving today. But our goal is to reduce litigation. Our goal is to get information out to help improve services for kids. Please reach out to us with additional questions and concerns. We want to do what's right for kids and make sure they get what's going on. Thank you, and I appreciate your service. Go enjoy your day. Be safe.